5 seconds. Start. The criminal appeal is directed against the judgment and order of conviction passed by the learned session judge. Full stop. The appellant herein was convicted for the offence punishable under section 302 of the Indian Penal Code and was sentenced to undergo imprisonment for life. Full stop. The brief facts of the case, as per the prosecution story, are that on the day of the incident, a heated altercation took place between the accused and the deceased over a long-standing property dispute. Full stop. According to the eyewitnesses, in a fit of rage, the accused attacked the deceased with a sharp-edged weapon, causing fatal injuries that resulted in immediate death. Full stop. The police conducted a spot panchanama, arrested the accused, and recovered the weapon used in the commission of the crime. Full stop. After a through investigation, a charge sheet was filed, and the case was committed to the session court for trial. Full stop. The session court, after considering the evidence produced by the prosecution and the testimonies of the witnesses, found the accused guilty. Full stop. However, in this appeal, the learned counsel for the appellant argued that the session court committed a grave error in appreciating the evidence. Full stop. It was conducted that the eyewitnesses were close relatives of the deceased and their testimony could not be considered independent or reliable. Full stop. Furthermore, it was argued that there were no fingerprints of the accused found on the recovered weapon, and the medical report did not consciously establish that the exact cause of the death. Full stop. The defense also claimed that the incident was not permitted but occurred during a sudden provocations, suggesting that the offense should be treated as culpable homicide not amounting to murder. Full stop. On the other hand, the learned public prosecutor strongly opposed these arguments. Full stop. It was submitted that even if the witnesses were relatives, their presence at the spot was natural and their testimony was consistent. Full stop. The medical evidence clearly indicated that the injuries were sufficient in the ordinary course of nature to cause death. Full stop. The intent of the accused to cause death was evident for the nature of the weapon and the force used. Full stop. This High Court has carefully pursued the records and heard both sides at length. Full stop. The court observed that the mere fact of witnesses being related to the victim is not ground to discard their evidence, provided it is corroborated by other circumstances. Full stop. In the present case, considering the gravity of the injuries and the nature of the assault, the act squarely falls within the ambit of section 300 of the Indian Penal Code. Full stop. There is no merit in the contention that the trial court's findings were preserved. Full stop. The evidence on record proves the guilt of the accused beyond reasonable doubt. Full stop. Therefore, this court finds no reason to interfere with the well-reasoned judgment of the lower court. Full stop. Consequently, the appeal stand dismissed and the conviction of the appellant is hereby upheld. Full stop. The authorities are directed to take the accused into custody to serve the remainder of his sentence. Full stop.